And she just attacked the lady in line.
Who did?
This lady right here to your left. Right here.
Hey, ma'am, come with me. Come with me. Give me your hands. Stop resisting. Hey, find out who it was.
On January 31st, 2024, Milwaukee County deputies responded to Mitchell International Airport following a physical altercation at the American Airlines ticket counter.
Come on over. She just came in the line and knocked her over. Yeah.
Stop it. Hey. We're just gonna step out. First of all, do you need medical attention?
No.
Are you alright?
Mm-hmm.
So what happened?
She was just walking around pointing at me. Just me.
That's what
We're taking her back.
I know, that's what I'm trying to
Yeah, I was just standing in line, minding my business. She keeps walking around pointing at me and saying, you, and comes up and just shoves me and smacks me.
Alright, I'm gonna ask you a very stupid question. I'm required by law to ask this. Did you consent to her pushing?
No.
Okay. It's a legal question that I'm required to ask. And you said that you do not need any medical attention?
No.
Did the shove cause any pain?
I was facing this way. She came up from behind me.
She shoved, and did she hit you, or just...
Straight on, pushed me and smacked me.
Where did she smack you? Just in the arm?
Yeah, I wasn't even looking at her.
Was it an open hand?
I don't know.
Okay. Do you have your ID on you?
Yeah.
All right.
We're not going to do that.
We got a squad coming up right now. Stand up. Someone pat her down real quick.
Right, that guy's watching.
So what happened?
Activist.
You're an activist? That gives you a right to punch someone?
Can you spread your feet for me?
Can't hear you.
Spread your feet.
Alright, you're going to have a seat in the squad, man.
Step in. It's fine. Anyone want to be a willing complainant and witness? Yeah, it just helps having extra witness statements of what happened.
Can we do it from online?
Yeah.
I'll tell you what happened. Come here. My name's Robert Boland.
Yeah.
I'm not coming back. So.
ID at all? It's easier to copy down. Because otherwise I'll stand here for 20 minutes saying, what was it? What was that?
Stupid. Oh, let me give you my business.
This is why I have this.
Yeah. But where did she come from, though?
Yeah, did you?
I thought she was trying to. I thought she had a little clumsy, right? She started saying, hey, you. Turn around. I was like,
I thought she was just going to be like, hey, what's up?
what I saw, officer, was this young lady in the blue sweatshirt.
All right.
Had like she was calling to someone, like she knew them, trying to get their attention. So we thought she was going to go there. I thought she was going to go get in line with them.
Okay.
No big deal. Came right through there. Went under the whatever the stupid thing is called.
One under the stanchion.
No, she passed right here.
All right. Okay.
Right through there. And I thought she was just walking up to talk to them because she was trying to get their attention, what it sounded like to me from standing here. And the next thing I know, she attacked them.
Yeah, she was pointing a finger at her and she was like, turn around.
And so,
Like she was trying to get someone that she thought
Right.
someone she knew's attention, and then she goes, "Hey, student."
where'd they come from? I'm going, damn, you know them? Personally?
Here, and then
Went right over, kind of tripped on that.
Tried to tear through a suitcase,
Went
and
to
all of a
hit
sudden
her
it got
with a bag
crazy.
or something.
All right.
And then she, after they separated, got them apart. She came over and said, "I worked at the Department of Defense and security, and wandering around up front and acting really crazy."
All right. Well, thank you very much.
All right, Summer, do you think there's anything happened that I didn't ask you about?
So that was it.
I'm just going to run you through it just one last time, I promise.
Sure.
All right, so you're standing in line, minding your own business. She just starts pointing at you, and then, where were you in line?
Like right there.
Right where you are? So she went past everybody that else was in line?
Right.
Okay.
And then
I mean, we're going to see on the footage because there's camera there,
there the whole time.
there.
But she like walked
20 minutes
around for a while. She like walked around. For a while. I don't know why.
I can't answer that question. Sometimes people
Just
that
be like that.
unfortunately. I wish I had answers. I wish there was a better system than this. But unfortunately, this is what we have right now. So you're standing right there. She comes up, shoves you from behind, and just says, "You," and then she just walked away, or
Yeah, well, they kind of like got her like off of me, and then I think she walked that way, and I
Just sit over there for a little bit until you guys come in.
and then kept like saying something, and I didn't really hear what she said, and then you guys came in shortly after. So,
All right, do you have any questions for me?
I don't think so.
Normally, if I had my squad, I would have like a form for you. It's called the Wisconsin Victims' Rights.
Sure.
This goes to court. You get somebody that's known as a victim witness advocate. Someone you can talk to that can help explain the whole process. What's going to happen probably is that you're going to get a phone call in the next couple of days from a district attorney's office. He'll talk to you, ask you some questions. Then you don't really have to do anything or show up until way down the road.
Sure.
All right, so honestly, it's gonna be like a time like you're gonna forget that it's kind of happened. Well, probably won't, but like it'll be so long that you're gonna be like, oh, that. That unfortunately, that's how slow everything is.
That's fine.
So, like I said, they'll contact you, and then the victim witness advocate will be the one kind of your go-between. They'll be able to answer any questions, explain the victim rights fund if there is like punitive damages or any injuries as a result of this. All right. Do you have any questions?
I don't think so. Thank you.
She's got a ankle brace. Ankle. Oh my god! I cannot think of. Do you want to right now, or do you know what they're doing? I know you're not. That's a sign.
You have the.
I need to sit down.
You have the ankle bracelet. What other jewelry do you have, ma'am?
I think she has some rings.
2 rings.
You can sit down on the bench if you want. While he's talking, if you need to
Earrings.
sit. That's it. That's not jewelry. Oh yeah, we can.
Yeah, we'll take that.
Yeah.
Little puppy there.
But we're putting it with all your property. I got it. You can put it
Yeah.
on top of that thing.
And
This is worth 5,000.
well, let's keep them puppies on for now. And hey, want to ask me these
This is from
questions?
Costa Rica. That is stamp. Oh, you know what? I'm wearing like, I don't know, $7,000 worth of jewelry.
I got to ask you 3 questions. Have you had any drugs or alcohol in the last 24 hours?
No, sir.
Do you have it or thoughts of hurting yourself?
No, sir.
Sick or injured in any way?
Are you sick or injured in any way?
No, sir.
Okay. You can just chill in here. We'll be right with you, okay?
This case demonstrates 3 critical legal principles: statutory element verification, probable cause convergence, and the limits of claimed immunity. The deputy's first action was interviewing witnesses. Under Wisconsin law, probable cause can be established through credible third-party accounts. When he located the victim, he asked a legally mandated question. "Do you consent to her pushing you?" The victim answered no. This was not casual conversation. Wisconsin statute section 940.19 defines battery as causing bodily harm with intent without the consent of the person harmed. That single question and the victim's explicit denial became the legal foundation of the prosecution. Without documented lack of consent, the charge fails. The deputy then canvassed for additional witnesses. 1 witness is a start. 3 consistent independent accounts or a prosecution. Robert Bowen described the suspect pointing at the victim, commanding, "Turn around," then pushing from behind. This corroborated the victim's account of being struck without warning. With probable cause established through multiple witnesses, the deputy had Fourth Amendment authority to arrest. The arrest occurred in a public place, so no warrant was required. During arrest, the suspect actively resisted verbal commands. The deputy gave clear orders. "Come with me. Give me your hands. Stop resisting." Under Graham v. Connor from 1989, use of force must be objectively reasonable from the officer's perspective at the moment force is applied. The deputy used minimal physical control, verbal commands, and handcuffing. No strikes, takedowns, or pain compliance techniques. This was proportionate to the resistance encountered. Wisconsin Statute 946.41 makes it a misdemeanor to knowingly resist an officer during a lawful act. The suspect's resistance created potential additional charges. After the arrest, the deputy asked an open question. "What happened?" The suspect responded with one word: "Activist." This statement was self-incriminating. It occurred before Miranda warnings. However, under Rhode Island v. Innis from 1980, spontaneous statements, not produced by interrogation, are admissible. The deputy's follow-up question was more problematic. Best practice requires Miranda advisement before any custodial interrogation. The suspect's claim to be an activist appeared intended as justification for the battery. Political beliefs do not create exceptions to criminal assault statutes. Witnesses reported she also claimed Department of Defense employment. Professional status, security clearances, and activist credentials are legally irrelevant once battery elements are established. The deputy then returned to the victim to provide statutory advisement. This was not optional courtesy. It was mandatory under Wisconsin law. Wisconsin Statute Section 950.04 requires law enforcement to notify crime victims of their right to a victim witness advocate, district attorney contact, and the Victim Compensation Fund. The deputy explained the charging process, set realistic timeline expectations, and ensured the victim understood available support services. Before booking, the deputy asked 3 mandatory screening questions: drugs or alcohol in 24 hours, thoughts of self-harm, and current illness or injury. This screening serves dual purposes: identifying detainees requiring immediate medical care and establishing documented baseline condition to protect both parties. The responding deputy receives a grade of B+. The arrest was constitutionally grounded and the investigation methodical. He verified the statutory consent element, canvassed independent witnesses, and applied force proportionate under Graham v. Connor standards. The single deduction reflects the absence of Miranda advisement before questioning. While the spontaneous utterance exception likely applies, best practice requires earlier advisement. The suspect receives a grade of D. She initiated unprovoked battery, actively resisted lawful arrest, and invoked unverifiable status to deflect accountability. Her fundamental legal error was believing resistance becomes lawful when the arrestee disputes validity. The remedy for alleged unlawful arrest is the courtroom, not physical resistance. The victim receives a grade of A-. Her account was consistent, legally precise, and her explicit denial of consent became the cornerstone of prosecution. The minor deduction reflects limited physical detail about the strike itself. Being attacked from behind, she could not describe the exact method of contact. However, Wisconsin's battery statute does not require proof of a particular striking method, only intentional harmful contact without consent. 3 key lessons from this incident. First, statutory elements require deliberate verification, not assumptions. The consent question was not casual. It was the legal foundation. Officers must identify and document every element the prosecution will need to prove. Second, probable cause is built from convergence. Multiple independent witnesses eliminate reasonable doubt about what occurred and strengthen prosecution significantly. Third, no identity shields criminal conduct. Professional credentials, political affiliation, or claimed authority provide no immunity once harmful physical contact without consent is established. Fourth, resistance to lawful arrest compounds legal jeopardy regardless of the arrestee's belief about the arrest's validity. The legal remedy is judicial review, not physical resistance. Fifth, victim rights advisement is not optional. Statutory requirements protect victims' due process and ensure they understand available support and their role in prosecution. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe for more legal analysis content.